Thank you for your presentations. Very interesting. We talked about a reply because we've gone so long. 1 minute, gentlemen.
Okay, got it. My white light is on, huh?
Except I'm not as ruthless as the Chief Justice.
Let me say one thing about each of these two areas. And first, just to be clear about what my position is, as I suspect you would realize, I'm not advocating, when I advocate originalism in criminal procedure, returning whole hog to what a trial looked like in 1791. Of course I'm not. When I advocate for the right to jury trial, I'm not advocating for returning to a system of 12 white male landowners on a jury, or all the other things Professor Bibas would point out. But I don't think that's any inconsistency with my position. Again, none of those things are required as part of the defendant's constitutional rights. All I'm insisting on is that these notions, jury trial, confrontation, as they were understood to be protections for the defendant, are the purpose of the Bill of Rights, and those things to be dealt with, and appropriately so, and thank goodness, by modernization and innovation in criminal procedure and evidence and all the like. So I don't see why you'd have to bring forward everything about what a trial looked like in 1791 to today. And the second thing, I'll just say a quick word about Melendez-Diaz, and I'm grateful to hear at least I have some measure of agreement there. I will say that even though I called it today a hard case, I was actually surprised to lose 4 votes in that case on all 4 people who decided it on the functionalist grounds, because for the reasons Professor Bibas said, I would have thought I had a pretty good story to tell about the practical horrors that we know of from the past generation of unchecked lab work. And so it's it just shows, I think, how once you get off the rails, though, and judges can do whatever they want, things get really hard. You mentioned something about autopsy reports, and let me just say, as another example of bringing originalism forward to today, that this is, I think, the hardest question in this field. At least it's the one that hits you in the gut the most. But it's always been the rule, and I guarantee you, if you look at the history, it is absolutely rock solid, that if any other witness became unavailable for trial, if you had a murder case where somebody had witnessed the murder, and then you don't catch the guy until 10 years later and don't bring him to trial until 10 years later, and the one eyewitness who knew exactly what happened and could recite it in court has now died, then the prosecution would be out of luck and wouldn't be able to use that witness's statements. And so I think there are lots of things labs can do in the autopsy context, having 2 people in the room, videotaping them, etc., to find ways to get around the confrontation clause and satisfy it in other ways. But again, when you have a problem and when the witness can't be in court, I'm prepared to insist on enforcing the right.
All right. Let me just respond only to the first of those points, which was, why is it that we can't just give defendants some of these pieces and not go backwards on others? I take Professor Fisher's theory on the jury trial to be, the jury is not there just to be a fact finder. It's to express the conscience of the community and to do full moral judgment on what this defendant deserves. Well, the full moral judgment requires the full picture involved at sentencing. It requires the stuff that's kept up by the rules of evidence. It requires the prior criminal record. It requires the evidence that was kept out by the exclusionary rules. I don't think you can say, we're going to give the jury the power to do this moral judgment, but we're going to put a thumb on the scales and keep them from hearing the things that really give them the full balanced picture.
In fine Federalist Society tradition, those of you who have questions, if you would now come to the microphones on the side, and while cues are forming, I will exercise the moderator's privilege and ask the first question. Sentencing and punishment has been one of the areas where, over the last 2 centuries, we've seen the most development in theories. So 100 years ago, there was a strong belief in rehabilitation. Again, the word penitentiary came from the word penitent. And there's a very famous building here called Eastern State Penitentiary. If you want to see ancient theories of penology, they actually built the architecture in ways that would encourage people to become better human beings. we've now abandoned that, and in that we had indeterminate sentencing where it was determined by a parole board how long you stayed in prison. And we've now moved to a world where there's greater taking it away from judges altogether, and now we have sentencing guidelines. And we've had a tremendous revolution in both the mechanisms and the theories that we're trying to accomplish through punishment. How would your points of view accommodate all this learning about how people change and their capacity to change, and how can we design a legal system that reflects that adequately?
Well, there's no doubt there've been a lot of changes over time in what we're trying to accomplish by putting somebody in a prison. Without going on for too long, I think that the way to do the analysis as a modern day originalist is to look at why we're putting them in prison today and compare that to why they were putting them in prison in 1791. And when it comes to modern sentencing laws, I think the equivalence is quite strong because the modern principle behind sentencing is explicit in the federal sentencing guidelines and the move to that and has been mirrored in the states is to punish. It is not to rehabilitate. So when you apply the historical principle of the jury had to find facts that expose the defendant to greater punishment, or to put it another way, that any fact that made the crime more serious needed to be proved to the jury, I think it maps on quite well today. I think it would be it would have been a much harder argument to have 100 years ago or even 50 years ago. But the way that we do things today, I think implicates quite strongly the historical reason for having juries.
I think while Professor Fisher has an important originalist point, I think what's perverse about the way the court has developed in this area is it said, okay, let's leave indeterminate, unstructured sentencing constitutional. Let's only regulate it originally when we give judges more guidance within that 0 to 20-year range on how to do things. I'd get it if you were being Justice Thomas and saying, fine, we're going to go back to saying the jury has to do everything. But it creates quite perverse incentives to say you can give unfettered discretion to the judge, but if the legislature starts to guide the judge, then suddenly that turns it into a sentencing factor for the jury. It's a very odd bird, and that's what leads us to a Sixth Amendment line of cases. It's about protecting juries, and Justice Breyer's big triumph is in Booker. He writes this opinion that's all about restoring discretion to judges by loosening up the federal sentencing guidelines. And it has nothing to do with juries by that point. And so I think, again, a little originalism is a dangerous thing. I think if we were willing to actually go back, it would work better as a package, but it has a real potential, kind of half-hearted originalism, to thwart many of the important developments in guiding and regulating and giving more due process notice and more procedural protections to defendants than they had up until the 1970s, say. Can
I say a quick word? Because I think it's important for the purposes of the debate to understand. I think, just for information, what almost all the states have done in response to this line of cases is step in and keep their sentencing guidelines, but have the juries find those extra facts. And I think that tells you an interesting thing about originalism and its consequences here, is that there's another part to this story which is leaving things properly to the democratic process. And I would argue, and this is a much bigger debate, but just to point it out, that Justice Breyer, when he stepped in Booker and created this amalgam system, actually did more harm than good. And if we would have left it to the legislature, we might be on a firm footing like we are in the states, where the right is actually protected through the democratic process.